So right out the gate, we've got 3 serious charges: retaliation, possession, and tampering. That's a cocktail judges do not like to sip on a Monday morning. Notice how the prosecutor is offering to dismiss 2 charges? That's a plea bargain move. But if Cooper passes this up, he's rolling the dice with all 3 counts in front of a jury.
Have the document that he's speaking of, and I'm willing to go forward today, but just strictly on removing of his house arrest. I think.
So you don't disagree with that? You agree?
No,
with
no.
You're contesting that.
I'm contesting. Except for the floor.
All right, let's go on this 22-41165. Justin Dakota Gotro. That's you, sir, here with your attorney, Mr. Gertz, and the state's attorney. Does the defendant waive a formal reading of this motion to revoke unadjudicated probation? Can we proceed in well, what are we doing? We're not doing an NTRP here.
This is just a motion to have a bond set. This was deferred adjudication probation. He has been in custody for almost a week now. And as the court knows, he's entitled to some kind of bond. And so we're asking the court to set a reasonable bond based on, and I'm happy to put him on about his ability to afford certain things or not, but
it's whatever you want to do.
Okay. Well, then Judge Matt,
what's the bond? There is no bond set right now?
There's no bond right now.
Stand by.
Risky move or confidence? You decide. Oof, Judge Stevens just snapped. And trust me, when this judge says, stop talking, you better stop talking. This is the kind of courtroom moment where one wrong word can turn a hearing into an arrest. You can feel the tension here. Cooper's frustration versus the judge's authority. Who do you think wins that battle? Yeah, probably not the guy in the jumpsuit.
Pre-sentence report, please. I'm not railing on, I just did on family violence, and here's one. What are the odds of that?
Prior facts not be taken into account for my client's case.
But
it's the same victim.
No, I mean the prior case. I'm not talking about my client's case. I'm talking about the previous case involving the pregnant woman not being considered.
No, I said his case. No, what I said was the importance about family violence, and there we go. We got a prior family violence assault conviction, right?
He's currently on probation for the same.
This was all part of the same.
It's the same victim in all the cases.
Incident judge has no other criminal history other than these items.
Well, help me out on this. Then, with that in mind, the indictment that he's on probation for alleges the state jail felony of criminal mischief.
Correct, Judge.
On or about September 11th, 2022.
That's correct, Judge.
The date of offense in the misdemeanor family violence assault says September 20th, 2022. That would have been 9 days later. Y'all are saying that happened at the same event?
It was a continuing event, Judge. If you read that first paragraph of the sentence, it kind of explains.
It's all tied to the same person and
but they were different acts.
Right.
I think
this intro nails it. Don't lie to Judge Stevens. If you've watched this channel before, you know that's rule number 1. It's honestly wild how many defendants think they can outsmart a judge who's been on the bench longer than they've been adults. Comment below, what's the worst excuse you've ever heard someone give in court?
Or are you saying there is one continuing criminal act over 9 days?
No, I'm not. No.
Okay. I didn't know how that was going to work. Let me look at this. Almost $12,000 in damage.
Yes, sir. So there was originally a theft and a criminal mischief. However,
The loss from damages were a total of $11,675.
right, and there was also a theft with I think
The
several
loss of
thousand.
stolen items were almost 1,000.
No, it was significantly more than that, Judge, because the ultimate.
Report saying.
Well, I understand that, but if you look at the judgment, the restitution amount is about 30,000. Yeah, 24,000. Sorry. But everything was packaged into this exact case right here, outside of the family violence assault.
All right, go ahead. What do you want to say?
Well, Judge, I want to ask my client some questions about his financial situation. If I can do that, do you want me to put him under oath or just ask him?
Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Justin, prior to your arrest, where were you working?
Prior to my arrest, I was working at the Collarwoods.
Okay. I'm sorry, prior to your arrest 10 days ago.
Oh, 10 days ago, I was unemployed, sir. I was doing odd jobs.
One of the odd jobs was working in the kitchen?
Yes,
Is
sir.
that right? What kind of money were you making working in the kitchen?
It was anywhere from 13 to 15.
And aside from that income, do you have any other sources of income right now? Okay. Do you have any stocks or bonds or cash or anything of that nature?
No, sir.
Okay. Do you have any real property that you own?
No, sir.
Okay. Do you have any debts aside from this restitution debt?
Aside from this, I have LIT college loans.
Okay, college loans. All right. And do you have any other source of income to pay for a bond in this kind of case? I mean, this, annuities, anything like that that's coming in or you're expecting?
No, sir.
Okay. Judge, I don't have any further questions.
Nothing from the state. Okay, what else?
That's it, Judge. We're asking the court to set a bond based on his financial constraints, obviously.
What about the elephant in the room? When was the last time, he reported for court-ordered probation report?
June of 23.
How long ago?
June of 23.
9 months ago? What about that?
Judge, I can't change the facts about that.
All right. Well,
that
kind of puts me in a bad spot.
there's no question, but I think the challenges my client had been, and I'm happy to get testimony about this too, but he had been.
I'm not telling you how to do your job. I'm just asking you because reporting, you're not on supervision if you don't report. You're on your own supervision, which is back assward. It's not the way it works. That's you're on your own probation. No. And the most important thing is the report. We have to have contact with them to prevent you from falling off the edge of the earth. And that's what essentially you did since June.
Okay, pause for a second. This is legal spaghetti. The defense is arguing these two offenses, criminal mischief and assault, were part of one continuing event. But the judge sees two separate crimes across 9 days. Why does that matter? Because if the court decides they're separate, that means double the exposure, double the punishment. Big stakes here.
Judge, we
Kind
have
of weird. It says, failed to report to the probation office for the months of Junely, Junly, which is
kind of a combination of June and July, I guess, but maybe that needs to get amended.
Does it mention July after that, Judge?
It says June, then August, September, and October.
Okay.
What do y'all think?
Well, we do need to amend that to reflect
So
June, July,
did he
August, September.
report in June? For June?
Yes, he reported June 19th.
Okay, what was he supposed to report another time in June?
Yes, it was supposed to be, I don't have the exact date that the officer gave him, but it was, he was on monthly reporting, so he has it that he didn't report in July, August, September, or October,
Okay, but my question
but
is,
not the exact date. I don't
did he report satisfactorily in June?
Judge, it looks like he did.
He did.
Okay.
So what we need is to amend that to July.
This needs to be July.
Yes.
Any objection?
No.
June late.
Read Julian calendar.
Okay, this correction is made on March 25th, this day.
Because he just.
What state that?
Well, Judge, I'm pretty much in agreement with everything you said. He stopped reporting the simplest of things that you can are required to do. Well, I mean, if the individual, the probationer stops reporting, I think the bond, if there is a bond, should be high enough to reflect that it'll ensure he comes back. And I'll also say that he's has $24,000 worth of restitution that he owes, and he hasn't paid a penny towards it.
When can we hear this? When can these are administrative. When can you be ready?
I mean,
3 weeks?
3 weeks.
All right. What I'm going to do is set a bond. This is $100,000. You must have a GPS device as a condition of bond. No contact with
The complainant.
let's see.
Susan Pate.
Is there anybody else other than the complainant named?
No,
I
sir.
guess not. Where would you live if you were released,
95 Guppy Street, Your Honor.
sir? Guffey?
Yeah, yes, sir.
Okay. Plus, you're still on probation, even though I haven't revoked it yet, which means you have to report, and you're going to be reporting weekly.
Yes, sir.
And if you do are released, the first thing you do on the way home is go, if it's, during the day, work hours, you go to the probation office to report, or if it's after hours, first thing the following business day. Okay.
Yes.
But you haven't been, and remember, you're looking at up to 2 years in the state jail. So we'll have this hearing set, everybody be ready, and we'll move forward on that day, okay?
We'll be ready, Judge.
Anything else?
No, Judge.
That is all. Thank you.
Is it sufficient just to have the,
Sir,
The prosecutor might be.
there's not an agreement?
It's for time, but he hasn't sent me the amount yet.
Doesn't matter what.
The amount of time.
Time served.
We can send you the amount of times. I don't know what it is.
It was for probation.
Chris Watson, or
It was for probation, but he said he'd rather just have time. That's why.
That's right.
He said he wanted time.
How much time? Oh, Mr. Watson here, please.
let me look real quick. Give me a second.
So he signed up.
It's a state jail felony, right, everybody?
Yes, sir. I
Yes,
just
sir.
don't know if there's prior to what there is. Let me look real quick.
I don't see any priors in the indictment.
No, sir.
For that. Here you go.
is 159 days credit.
One second. You're, did you grow up in Beaumont? Speak out, please.
Yes, sir.
Okay. And let me see his criminals. I don't see any.
Boom. A $100,000 bond and weekly probation check-ins. That's the legal version of a short leash. Judge Stevens is basically saying, you vanished once, try it again, and see what happens. Notice how he's tying every privilege to compliance? That's courtroom accountability in real time. It's tough love, but it's law and order, Texas style.
Other felonies? Do you have any other felony? Nothing? You haven't lived anywhere else other than in Beaumont, Southeast Texas?
Yes, sir.
What's, is there a loss here?
That's what I'm looking. I'll see, Judge. I had a chance to look at this, Mr. Eckhart's case. Trying to pull up the documents now.
Broke the front glass door. Removed property from the interior of the business.
Yeah, I don't see anything was sent back to us yet.
Yeah, but he broke, somebody's going to have to pay for it. Plus, when he was arrested, Jonathan Konefsky, huh? Where'd you come up with that name? Chris?
Well, what did I tell them?
You told him Jonathan Konefsky.
What's my
Is
name?
that the first thing you came up with? That was.
When is my arrest date? What is my arrest date?
The day you were taken into custody.
Yes,
Come on,
what
that you
day
broke
is-
into the building.
What is the date in the month?
What
Just stop. Just stop doing it. You're going to drive me crazy.
does that matter? Does that trigger your memory in some way? I mean, I don't mean to be smart, but you were there. You know what happened, sir. You called yourself a Jonathan Konefsky, and then they later found out at the
What's
jail.
my name? Do you have my name now? Do you have my name now? Yes. What's my name?
I ask you the next question because
I don't have
I'm
a confusion about what my name is now.
Uh-huh.
They caught him at the scene, Judge. So it looks like it would just be the door because Beaumont has other stuff in property,
Do you have money to pay for the door?
No,
which
sir.
they show the officer put in his report. The door is about $100.
So how do those people get their property back?
I don't know. I don't know how they do that.
Just to be back on what I have written on my notes, Mike, look, the offer was a deferred $600 fine plus restitution, but he told me he was rejecting that. He did not want any kind of probation and he wanted a jail offer. So that's why I said the jail.
We'll just set it for trial. 2 years. Okay. We'll set it for trial. And Mr. Adams can continue to represent you. He's a very good lawyer. It probably would go to trial quicker if you agreed to release him, but that's your business. He's a good lawyer. What do you want to do? Keep him? We'll set it.